or unspoken, within the general staff of the Kosovo Liberation Army, in which Mr. Thaçit was involved to abuse the human rights of either collaborators or people perceived to be opponents of the KLA? His answer, no, I wasn't. Question, were you ever aware of any agreement, spoken or unspoken, to unlawfully intimidate people perceived to be opponents of the KLA or collaborators, or to commit violence against them, or to remove them so that the KLA could seize power in Kosovo? His answer, no, I wasn't. Slide 8. I will discuss Bislam Zarapi's evidence and the SPO's treatment of his evidence in a moment and in some detail. But for now, I draw your attention to the SPO's assertion on Monday, where they described Zarapi as, quote, the one general staff member who did not form part of that group of trusted persons. He was the only outsider. That's a transcript 28468. Slide 9, please. This is consistent with paragraphs 1431 and 1432 of the SPO's final brief, wherein the SPO asserts that Zarapi's past and present testimony has been, quote, broadly consistent, close quote, but tries to dismiss his exculpatory evidence for Mr. Thaçit on the basis that he was allegedly, quote, not part of the general staff inner circle to which the accused belonged, close quote, and was, quote, not fully trusted by all KLA members, including certain members of the general staff, close quote, and therefore, quote, such factors would affect the extent to which the JCE members would openly discuss opponent policy with him. The SPO goes on to assert in paragraph 1433 that Zarapi, quote, has given largely consistent evidence over time before different courts and stood behind those statements. This is consistent with the way the SPO has pleaded its case, namely, at no time has the SPO identified Zarapi as a named or even suspected member of the alleged JCE. In summary, the SPO's position is that Bislam Zarapi is generally a credible witness. He was not identified as part of any JCE and is not alleged to be by the SPO. The SPO's case is that those who were JCE members kept discussions of their criminal purpose from him. The SPO's position on Zarapi has significant implications on the overall credibility of the SPO's case. Why? Slide 10. Because for most of the indictment period, Zarapi was either the head of operations of the KLA or the chief of the general staff. He was therefore at the very center of the KLA's operations. He went out into the zones and was with Mr. Thaçit when Thaçit was in the zones, including near Rahovec in July 1998, in the Shala and Lap zones in August 1998, and in the Dukajin zone in September of 1998. You see that on your screen. The SPO final brief argues that all of these visits to the field by Mr. Thaçit and others were for the purpose of conveying and implementing the common criminal purpose. Slide 11. And yesterday, you heard Mr. Halling cite P00607, a newspaper interview given by Mr. Zarapi, which the SPO bar-tabled and which was never shown to Zarapi by the SPO for comment. The SPO quotes the newspaper article in support of the claim that Zarapi had sought the consent of Thaçit and Veseli in order to install men who would oversee, in the words of the SPO, a torture operation. Slide 12. We are, of course, prejudiced by the SPO's failure to put this argument to Zarapi or anyone else. But how does the SPO reconcile its position that Zarapi was not a named member of any JCE, not trusted by the JCE members, with the fact that Zarapi traveled with Mr. Thaçit to each of these visits and not only attended, but participated in the discussions? How does it reconcile its position that it was Zerapi who installed men operating a torture operation with its argument that Zerapi was not in the JCE and not trusted by the JCE members? Slide 13. How does the SPO reconcile its claim that Thaçit implemented the common criminal purpose in these meetings in the field with Bislam Zerapi present for all of them, with its position that Bislam Zerapi was not a named member of the JCE and the so-called JCE members tried to conceal the common criminal purpose from him? The SPO does not say. And this is a common problem throughout the SPO final brief and its closing statements. They simply ignore all of the trial evidence that discredits their case. The Chires video is but one example, which I will get to later. Reviewing the SPO final submissions is like reading a movie review written by someone who didn't watch the movie. Slide 14. Zerapi testified that in these visits to the zones, he had heard complaints about treatment of prisoners within the zones, and this was the reason that he issued orders in November 1998 as Chief of the General Staff to try to put a stop to any mistreatment of persons. This testimony is corroborated by the contemporaneous written order, which you have in evidence as Exhibit 1D29. The SPO final brief does not challenge Zerapi's evidence on this point, or that his order 1D29 was made in good faith. Indeed, this order corroborates the agreed position of the defense and the SPO that Bislam Zerapi was not a member of the alleged JCE. While we were on the order, you heard Mr. Teeger on Monday suggest that the 28 November 1998 order was understood not to apply to collaborators because they weren't deemed to be civilians. And that's at transcript page 28400. However, this is not what the SPO said in its final trial brief. As you see on this slide, in paragraph 871 of the SPO final brief, the SPO refers to general staff orders to detain collaborators. And if you look at the documents cited in the footnote, 1D29 is one of them. Slide 16. Zerapi also confirmed in both his SPO interview and his trial testimony that the order applied to collaborators as well, and that's on your screen as well. Slide 17. But even looking at the order, there is nothing to suggest that it excludes collaborators. I draw your attention to paragraphs 1, 3, and 4 of the order. Paragraph 1, stamp out the negative phenomena and abuse against persons. The same in paragraph 4, referring to the arrest, detention, or imprisonment of persons. The words there do not say civilians. When the order wanted to refer to civilians specifically, it did so expressly, as in paragraph 3. Slide 18. So how does the SPO reconcile its position that Zerapi, the chief of the general staff, was issuing orders that allegedly were at counter purposes to the alleged common criminal purpose of other members of the general staff? Why would the JCE members allow him to obstruct their criminal objective? Again, the SPO does not say. We say that 1D29, issued by someone at the very heart of the KLA's operations, establishes a reasonable interpretation of the evidence that there was no JCE involving the general staff, as alleged by the SPO. Slide 19. Another problem that Zerapi poses for the SPO concerns the SPO allegation in its final brief that certain directorates of the general staff were instrumental in implementing the common criminal purpose, including the Civil Administration Directorate, the Military Police Directorate, and the Personnel Directorate. However, all of these directorates were subordinated to whom? To Bislam Zarapi as the chief of the general staff. You see here on this slide an organogram of the general staff which the SPO showed you on Monday. You see here that these directorates are alleged by the SPO to have been directly subordinated to Zarapi. You see here that they are not alleged to have been subordinated to Mr. Thaçit. You should also note that the SPO confirmed that in addition to the accused, those in the black boxes are alleged JCE members, and those that are not in the black boxes are not alleged to be JCE members. Zarapi is one of those not alleged to be a JCE member. Slide 20. The SPO also noted during their closing statement that Zarapi was receiving reports from the zones about special warfare. However, their position is also that Zarapi was not in the JCE. Slide 21. So how does the SPO reconcile its position that multiple directorates of the general staff were implementing a common criminal purpose, even though the person responsible for leading them was not alleged to have been? And how could he have been unaware of such a criminal purpose if they were directly subordinated to him? Slide 22. The next issue for the SPO concerns its repeated claim throughout its final brief that the general staff made its decisions collectively through a collective decision-making process. See paragraphs 64, 103, 113, 471, 480, 481, 504, 512, 515, and 612 of the SPO brief. Indeed, in paragraph 64, the SPO asserts it relies on the 2006 ICTY statement of Sokol Bashota for the claim that, quote, there was a collective decision of the general staff authorizing further measures for collaborators. The SPO's case is that general staff reached decisions collectively, including in the case of collaborators. Slide 23. The SPO's case also does not allege Zarapi as chief of the general staff to have been a JCE member himself. In their final brief, the SPO has clarified further that Zarapi was allegedly not part of the general staff inner circle to which the accused belonged and was, quote, not fully trusted by all KLA members, including certain members of the general staff, and therefore such factors would affect the extent to which the JCE members would openly discuss opponent policy with him. As noted earlier, this has now also been confirmed in the closing statement. Putting aside for a moment the lack of credibility of the Bashota 2006 ICTY statement, which I will address later, the SPO, by acknowledging that Zarapi was not a JCE member, necessarily acknowledges that collective decision-making, even in the case of collaborator policy, does not automatically put every general staff member in the JCE. Otherwise, the SPO would have identified Zarapi as a JCE member, especially given he was the chief. Slide 24. If leadership of the general staff does not automatically make Bislam Zarapi a JCE member, as the SPO acknowledges, then mere membership in the general staff cannot make Hashim Thaçit a JCE member either. Slide 25. The SPO stated on Monday at transcript page 28366 that there can be no conviction on the sole basis of being a member of the general staff. We agree. Slide 26. You may be saying to yourself, well, Mr. Mishetic, what about the documentary evidence? Maybe these international witnesses were unaware of the smoking gun orders from Thaçit to beat and kill opponents. But there are no such documents implicating Thaçit. There are no general staff orders in which detention and mistreatment of so-called opponents is suggested. And the SPO does not claim otherwise. On the contrary, The only order on the issue of civilian detention is the one I've mentioned, 1D29, where Zerapi ordered the proper treatment of persons. There are no orders in the record from Thaçit to perpetrators of crimes. There are no reports from perpetrators of crimes to Thaçit. There is no credible evidence that Thaçit authored communiques, or let alone that he authored any inflammatory communiques. There is no credible evidence that any KLA communiques significantly contributed to any of the crimes charged in the indictment. And there is no credible evidence that he was personally involved in the commission of war crimes. And I will address this point a bit later in my submissions. Slide 27. The SPO asks you, the trial panel, to thread an incredibly small eye of a needle. They ask you to find that there is no reasonable doubt of the existence of a joint criminal enterprise in 1998 and 1999 within the KLA General Staff, in which Hashim Thaçit was a participant, a JCE which committed war crimes and crimes against humanity in order to, quote, gain and exercise control over all of Kosovo, but also ask you to find that it would not have been evident to international officials and the NATO countries which intervened militarily on the side of the KLA. The SPO asks you to make the finding that the JCE would not have been evident even to the Chief of the General Staff. And it asks you to make this finding in the absence of any internal documents where any such plan to target so-called opponents for the purpose of gaining and exercising control over all of Kosovo was ever suggested, let alone discussed. There are not even any books, memoirs, or manuscripts where any such plan is recollected. In the words of General Clark, the SPO asks you to find that this was quite the elaborate deception. Slide 28. The SPO effectively asks you to tell the world that you are going to rewrite the history of the Kosovo War based almost exclusively on inference, because there is no direct evidence supporting their allegation of a common criminal purpose. And they ask you to draw these inferences after a trial in which the SPO was too afraid to put its theory to a single witness, whether called by the SPO or the defense. The SPO's fear, and I don't use that word loosely, its fear of putting its case to any witness in this trial is an admission of what the SPO thinks of its own case, of its own lack of direct evidence to confront witnesses who dispute their case. Slide 29. Until now, the jurisprudence of international courts and tribunals has found that NATO intervened militarily in Kosovo in 1999 in response to a Serbian JCE that began no later than October 1998. The SPO is asking you to find, on inference alone, that actually it was the KLA that had plotted a joint criminal enterprise months and perhaps years earlier, but no later than March 1998. Moreover, the jurisprudence of the ICTY has established that the Serbian political leader, President Milan Milutinović, was not criminally responsible for the events in Kosovo in 1998 and 1999, precisely because he was a political figure who did not have effective control over FRY forces and therefore did not make a significant contribution to a JCE. The SPO asks you here to find that although the Serbian president of an organized and well-established state was not criminally responsible for massive war crimes and crimes against humanity due to his lack of effective control, you should, on inference alone, find that the Kosovo Albanian political leader of the KLA, a non-state armed group only months in existence, had effective control and was criminally responsible. That result would be a perversion of history and a legal and historical injustice. Slide 30. Your Honors, the SPO's case is not the only reasonable interpretation of the evidence, which is the standard that must be met in order for you to rewrite the history of Kosovo in this case and to convict Hashim Thaçi. There is ample reasonable doubt for you to enter a judgment of acquittal on all counts. I will turn now to the section, was there a JCE? Slide 32, please. At the core of the SPO's case is its central allegation that there was a common criminal purpose to, quote, gain and exercise control over all of Kosovo through the commission of war crimes and crimes against humanity. As I've said, the SPO asks you to find beyond any reasonable doubt that such a common criminal purpose existed based purely on evidential inferences. There is no direct evidence that any such plan ever existed. No evidence of any meetings where any such purpose was discussed. No documentary evidence of any such purpose having been agreed or discussed. No witnesses testified to the existence of any such purpose. Indeed, every witness who had an opportunity to address the issue denied the SPO's theory. Even worse, the SPO never put its case to witnesses. The SPO's claim on Monday that it is using direct evidence in support of its case reflects a fundamental misunderstanding of what direct evidence is. Direct evidence is evidence that proves a fact in issue without the need for any intervening inference. What is the direct evidence of a common criminal purpose which was unknown to Zarapi and the international community? Next, the SPO cites no evidence of general staff meetings where the common criminal purpose was agreed or discussed. And the SPO makes no claim in its brief that Thaçi ever attended a general staff meeting where targeting of opponents was discussed. Slide 33. The SPO makes the sweeping claim at paragraph 75 of its final trial brief that, quote, opponents and special warfare were discussed on a recurring basis at general staff meetings. But there is no discussion in the SPO's brief about any such meetings. The SPO leaves it to the trial panel to dig into the footnotes and retrieve the cited documents in order to discover what meetings the SPO is talking about and what was discussed in those meetings. And when one checks those footnotes, one sees why the SPO avoided any substantive discussion of KLA general staff meetings. Slide 34. For example, in footnote 283, the SPO is only able to identify 2 meetings where it claims opponents and special warfare were discussed. A meeting on 16 August and another on 29 December. Slide 35. The August 16 meeting was a meeting where there was a very specific discussion about the KLA being targeted for takeover by Tahir Zemai and FARC. First, the SPO has not established that Mr. Thaçi was even present at this meeting. Indeed, the SPO final brief makes no claim that Mr. Thaçi was present at this meeting on the 16th of August. And you see the testimony of Bislam Zarapi there on your screen, both from his SPO interview and his trial testimony, where he confirmed that he was present for that meeting, but did not have a recollection of Mr. Thaçi having attended. The next slide is not for public broadcast. Slide 36. Second, the panel has seen evidence that it was not the KLA that targeted Tahir Zemai, but rather Tahir Zemai and Buyar Bukoshi, who had targeted the KLA to have Bukoshi take over control of the KLA. There is nothing in the evidence to suggest that there was any discussion of a broader policy to target so-called opponents in order to gain and exercise control over all of Kosovo. This next slide may be broadcast for the public. Slide 37. The second meeting the SPO cites is a 29 December meeting, which Mr. Thaçi did not even attend because he was out of the country. and the SPO does not allege that he attended the meeting. Accordingly, the SPO in its final trial brief has not been able to identify a single meeting of the General Staff which it alleges Mr. Thaçit attended and where the topic of opponents or special warfare were ever discussed. As an aside here, Your Honors, let me remind you that the SPO on Monday told you that Sokol Bashota's 2006 ICTY statement, in which he is recorded as having said that the General Staff would collectively issue an order to kill collaborators, was not hypothetical, as Bashota told you it was. I will address Bashota's 2006 statement a bit later, but for now, it is sufficient to point out that the prosecution has not identified any such meeting where any such discussion would have taken place. The only meetings the SPO cites are those two, 16 August, 29 December. Slide 38. Your Honors, putting aside for a moment the fact that the SPO does not even allege Mr. Thaçit was present for either meeting, it is important here to contrast the SPO's claims that opponents and special warfare were discussed in the meetings of 16 August and 29 December, with the SPO's position that Bislam Zarapi was an outsider, he was not a member of the JCE, was not trusted by the alleged JCE members, and that the JCE members would not openly discuss the so-called opponent policy with him. Slide 39. Zarapi told you he attended the 16 August meeting at transcript page 17389. You see that testimony on your screen. If Zarapi was present for the discussion, then there is a reasonable inference for you to draw that there was no discussion about gaining and exercising control over all of Kosovo through the commission of war crimes and crimes against humanity, in light of the SPO's acknowledgement that Bislam Zarapi is not alleged to have been a member of the JCE and would not have been involved in any such discussions. Moreover, the SPO asked Zarapi about a discussion at the 16 August meeting concerning the appointment of commanders and formation of brigades, but never asked him a single question about whether there was a discussion about targeting opponents at that meeting. The SPO cannot claim that Zarapi was not being candid about that meeting because of a, quote, climate of intimidation in Kosovo, if it never put its case to him about that meeting. Slide 40. Zarapi was also present for the meeting on the 29th of December. Indeed, Exhibit P621 demonstrates that it was Zarapi himself who convened a meeting of his directorates on 29 December. And P1408 demonstrates that Zarapi himself chaired the meeting, which was attended by B. Luja, Adam Grabovci, Fatmir Limaj, Ram Buya, and Sali Vaseli. And you see that evidence on your screens now. There is no evidence that any of the four accused attended this meeting, and it has not been disputed by the SPO that Mr. Thaçit was out of the country. The SPO cites to this meeting, and in footnote 283, in support of its contention that opponents and special warfare were discussed on a recurring basis in General Staff meetings. Slide 41. But how does a meeting that did not involve any of the four accused and was chaired by Bislam Zarapi, not trusted by alleged JCE members, support the SPO's contention that there was a common criminal purpose involving these four accused? The SPO is silent. The SPO suggested in its re-examination of Zarapi that there may have been two meetings on 29 December, one chaired by Zarapi that involved the meeting of his directorates, and another of the General Staff. But this has not been established by the evidence, nor has the SPO established who attended such a second meeting on 29 December. Moreover, the SPO has not established that Zarapi did not attend such a meeting. The SPO never put to Zarapi that he did not attend such a second meeting. Accordingly, again, this raises the question of how the SPO could contend that the 29 December meeting was a meeting in furtherance of the common criminal purpose, given that Zarapi was likely present at the meeting and was not kept informed about the common criminal purpose according to the SPO. Slide 42. And that's it. That's all of the evidence the SPO cites to allege that opponents and special warfare were ever discussed at General Staff meetings. There is no assertion by the SPO in its brief that Hashim Thaçit attended a single such meeting. Slide 43. At paragraph 110, footnote 402 of its final brief, the SPO has laid out what it claims is a list of General Staff meetings. Slide 44. And in footnote 405, it has laid out a list of alleged Provisional Government of Kosovo meetings. For the record, we dispute that any of these meetings are official meetings of the Provisional Government, as opposed to meetings where some members of the Provisional Government were present. Despite all of these meetings, they are only able to allege 2 meetings where the issue of special war was ever discussed, and those are the 2 I've already addressed. Slide 45. Mr. Thaçit was out of the country for much of the indictment period, and there is no evidence that he attended most General Staff meetings. Slide 46. The SPO in paragraph 113 tries to circumvent its problem of Mr. Thaçit's absence from Kosovo by arguing that the General Staff members were consulted by phone or else informed afterwards of the results of General Staff meetings. But the only example they cite is the case of the 8 Yugoslav army soldiers, the 8 VJ soldiers. We submit that the case of the 8 VJ soldiers is the exception rather than the rule. You can't take the specific case where Mr. Thaçit was involved on the basis of his role, in the words of Ambassador Hill and Sean Burns, as the foreign minister, and was pulled into the discussion of the 8 VJ soldiers because high-level American diplomats, such as Ambassadors Hill and Walker, and the international community were involved, and then extrapolate from that one incident that on every decision of the General Staff, he was consulted by phone when he was out of the country. That requires evidence and cannot be the only reasonable inference. Moreover, the SPO implicitly acknowledges in its final brief that just because someone had a role in the release of 8 VJ soldiers does not mean that they were members of a JCE or otherwise bore criminal responsibility. The next 3 slides are not for public broadcast. Slide 48. Bislam Zarapi was directly involved in the incident concerning the release of the 8 VJ soldiers. He was extensively examined about his involvement by the SPO. That's at transcript page 17520 to 17523. He was involved in the cases of several other detained persons. The citations are shown on your screen. Yet the SPO acknowledges that he was not part of any criminal purpose, just because he was involved in discussions about their release. Slide 49. The same applies to Hashim Thaçit. Just because he was consulted about the release of 8 Serbian soldiers because it was an international incident with diplomatic ramifications does not give him any more of a criminal role in detentions than it does Bislam Zarapi. Slide 50. Furthermore, the fact that other members of the General Staff chose to ignore Thaçit's position that KLA and Serbian soldiers should be simultaneously released demonstrates that Thaçit's views were not decisive on such issues. The next slide can be publicly broadcast. Slide 51. In support of its assertion that absent General Staff members would be informed about the results of General Staff discussions after their return, the SPO uses as an example its claims in paragraphs 114 and 148 that Suleiman Salimi in February 1999 was only proposed by zone commanders to be the overall commander, and that his appointment was not approved until the return of the Rambouillet delegation. Slide 52. This claim is refuted by Exhibit 1D250, which establishes that Suleiman Salimi was publicly declaring himself as the overall commander of the KLA on the 22nd of February 1999, while the KLA delegation was still in Rambouillet. You see that evidence on your screens. Suleiman Salimi was installed by the zone commanders, not simply proposed by them. You heard that from Bislam Zarapi as well. While we are on this point, Mr. Quick said on Monday that while the final decision regarding the Rambouillet agreement was signed by other General Staff members, it was not signed by Suleiman Salimi. That was said at page 28481 to 28482. Notably, the SPO never put its case to Suleiman Salimi or anyone else that he allegedly did not consent to the Rambouillet agreement. Yet again, the SPO was too afraid of the answer. Slide 53. But as you see from the excerpt of Suleiman Salimi's interview on this screen, which the SPO admitted into evidence, Salimi confirmed that Thaçit consulted him and Salimi gave him his consent thereafter. This is the only admitted evidence that directly addresses the issue. Slide 54. And this next slide shows a photo from the meeting in March 1999 when Salimi gave his consent to Thaçit. Once again, this is the SPO's own exhibit. Slide 55. As a final note here, yesterday, while discussing the February meeting that took place between the zone commanders and several members of the General Staff, Mr. Halling stated that the defense was attempting to brand the meeting as a coup by the zone commanders. That was at transcript page 28519. The SPO never challenged Remy's acknowledgement of the coup, nor Zarapi's acknowledgement of the coup, nor Sean Burns, who was on the ground in Kosovo, had extensive contacts with the KLA, and was cross-examined extensively on the coup and confirmed that he was aware of the coup. In fact, it was not the defense who called it a coup, but Burns who called it a, quote, palace coup in a code cable which the prosecution admitted as Exhibit P1080. To say that there was no coup or that there wasn't a reasonable inference that there was a coup is yet another unserious argument by the SPO. I would like to spend a few more minutes going over the testimony of Bislam Zarapi and how else his evidence affects the SPO's JCE case. The SPO's admission that Zarapi is a credible witness and that it does not allege he was part of any joint criminal enterprise is a crucial blow to the house of cards that is the SPO's case. Slide 56. He was the chief of the General Staff. You see his testimony on your screen where he acknowledged his role as chief of the General Staff and his acknowledgement that the directorates were subordinated to him. He was at the center of everything in the General Staff. If there was a JCE in the General Staff, there is simply no way he would not have known about it. And his order in 1D29 establishes a reasonable inference that he was not in any JCE and that there was no JCE. The next two slides are not for public broadcast. Slide 57. Zarapi's evidence is that there was no JCE in the General Staff, and he has been saying this since at least 2005, where he told the ICTY that prior to late November 1998, the General Staff had issued no orders on the issue of detentions, and that detentions were a matter that had been handled by the zone commanders. He told the ICTY that he had heard complaints about such detentions when he visited the local commanders in the zones, and that he issued an order in late November 98, which you know as 1D29, in order to be able to take disciplinary measures and for soldiers to know what the right procedures were. You see his 2005 evidence on your screen. Slide 58. Zarapi also told the ICTY in 2005 that, quote, Until late 1998, it is an obvious fact that more power laid in the hands of zone commanders than in the hands of the general staff. The next slide may be broadcast to the public. Slide 59. Before you, he agreed that the February 1999 coup by the zone commanders actually demonstrates that the zone commanders continued to have real power well into 1999 and not just until late 1998. Slide 60. Zerapi has been saying for more than 20 years that there were no general staff orders concerning detentions prior to his order in late November 1998. Zerapi has been saying for more than 20 years it was the zone commanders who had been detaining people, not the general staff. The SPO cannot dismiss his evidence as that of someone who is now changing his evidence due to a climate of fear in Kosovo or because of a relationship with Mr. Thaçit. He has been consistent on his evidence over a very long period of time, which the SPO admits in paragraph 1433 of its brief, wherein it says that Zerapi, quote, has given largely consistent evidence over time before different courts and stood behind those statements. Slide 61. How could Zerapi, who was the one issuing many of the orders, not know if such a policy existed? At paragraph 74 of the SPO's final brief, you see there on your screens that the SPO says that Zerapi on 28 November 98 issued an order which, quote, increased centralized control over arrests and detentions by directing that they could only be ordered by brigade commanders and higher superiors, except in critical military situations or when there were, quote, criminal acts against members of the KLA, individuals, or civilian authorities. So the SPO is telling you that it was Zerapi who was increasing centralized control over arrests and detentions, but that he was someone whom the JCE members did not trust to include in the criminal overall policy and is not even alleged to have been a JCE member. Slide 62. So how does the SPO reconcile the chief of the general staff being outside the criminal purpose, but exercising centralized control over detentions and arrests? Well, in footnote 280, they cite Zerapi's evidence that the order was issued as an attempt to address complaints about conduct of KLA soldiers and that the general staff, quote, wanted to show the internationals that we were a disciplined army. And you see both the SPO's footnote and Zerapi's testimony here. This is exactly what we say. The general staff knew it needed the international community. It wanted to be seen as complying with international law and standards. Zerapi issued such orders precisely for that purpose, among others. This clearly establishes a reasonable interpretation of the evidence that the general staff was attempting to stop mistreatment of persons and not instigate it. Slide 63. If the accused were involved in a common criminal purpose to commit war crimes and crimes against humanity in order to seize power in Kosovo, Bislam Zerapi would have had to have known about it, and he denies any such purpose existed. The SPO has told you he is a credible witness. How could any reasonable trier of fact come to any other conclusion but that Zerapi's evidence alone establishes reasonable doubt about the prosecution's case? And when Zerapi's evidence is considered in the context of the parade of international witnesses who told you essentially that they agree with Zerapi, what else needs to be said? Slide 64. How was the common criminal purpose allegedly disseminated to the lower levels? The SPO has laid out its allegations in its table of contents right there. That's how they allege it was disseminated to lower levels. Through dissemination in public statements, dissemination in regulatory and training documents, and dissemination in meetings and reports. And I will allege each of these in turn. But you should note here on the SPO's own table of contents, in a section identifying its arguments about how the common criminal purpose was transmitted to lower levels, that there is a concession by the SPO that it has no case that any criminal plan was transmitted through any written orders. The first alleged means is public statements. Slide 65. And the first means of public statements is communiques. But there is yet another fundamental contradiction in the SPO's case. On the one hand, the SPO says that the KLA had a fully functioning command system from the general staff down to the zones. That's at paragraphs 105 to 109 of their brief. The ability to communicate between the general staff and the zones. That's at paragraphs 210, 218, and 219. The ability to issue binding orders from the general staff to the zones. That's paragraph 128. And the ability to instill discipline and punish lower levels for noncompliance. That's at paragraphs 141 and 285. Next slide. But the SPO says that despite this fully operational system of command and control, a, quote, core means, close quote, by which JCE members communicated the alleged opponent policy was through communiques, political declarations, and other public statements of the JCE members, which the KLA soldiers had to obtain through public media. That's paragraph 67 of their final brief. Slide 67. Slide 67. The SPO does not explain why the JCE members did not simply issue orders targeting the so-called opponents. We submit it is because the SPO case is internally inconsistent, and in fact, there was neither command nor control, nor any credible evidence that the zones interpreted communiques as establishing a policy to commit crimes against people perceived to be obstructing the JCE members' alleged desire to take control of Kosovo. Slide 68. In paragraph 225 of its final brief, the SPO also says, under Thaçit's leadership, the political and information directorates were key in the formulation and dissemination of internal and external policy, including in relation to the identification and treatment of opponents. Through the issuance of statements, political declarations, and communiques, the Information Directorate disseminated the information and propaganda which the Political Directorate shaped. I will address the SPO's claims concerning Mr. Thaçit's alleged leadership of the Political and Information Directorates a bit later. But for now, let me highlight yet another contradiction in the SPO's case. Slide 69. On the one hand, their case is you should discount the evidence provided to you by multiple high-level international officials, some called by the SPO, such as Sean Burns, and others called by the defense, such as James Rubin, Christopher Hill, General Wesley Clark, James Jock Covey, John Duncan, Paul Williams, and Michael Durkee, because all of these internationals did not have information available to them that you have available to you. But their case against Mr. Thaçit hinges in part on statements, declarations, and communiques that were by definition in the public domain and readily available to the international media, diplomatic, and intelligence communities. The internationals were well aware at the time of all of these, and they did not see an incitement to crime or a common criminal purpose. Slide 70. And what about Mr. Zarapi, the insider, the chief of the general staff, who was not aware of the common criminal purpose and from whom the other JCE members concealed the common criminal purpose according to the SPO? If the communiques and public statements were the means through which a criminal policy was transmitted, how does the SPO explain why Zarapi didn't get the message? Did he not read communiques and political declarations? Why would the SPO say that other members had to make efforts to conceal the common criminal purpose from Zarapi, while at the same time those same JCE members were broadcasting the common criminal purpose in the media? None of this, Your Honors, makes any sense, let alone constitutes proof beyond reasonable doubt. how is it that the SPO can argue that both the internationals and the chief of the general staff didn't know about the common criminal purpose, but the lower level KLA personnel were able to receive the criminal message? Slide 71. Ask yourselves this question. Did it take 20 years for the international community to discover the insightful propaganda of the genocidaires in Rwanda? Did it take 20 years for the international community to discover the nationalist propaganda of the Bosnian Serbs and the Milosevic regime? Of course not. The inflammatory rhetoric in Rwanda and Serbia and Bosnia was self-evident and immediately reported. And had the KLA's communications been inciting crimes in Kosovo, the international witnesses from whom you heard would have known about it. The SPO's case is that by the time Mr. Thaçit was in Rambouillet, a persecutory KLA campaign of war crimes and crimes against humanity had been unfolding for 11 months. Yet Professor Paul Williams told you that no one in the contact group ever mentioned to Thaçit that he needed to do something. Instead, Williams told you it was Thaçit and the Albanian delegation pushing for the ICTY to be allowed to investigate war crimes by all sides, including the KLA. Slide 72. The next point. The SPO has failed to prove that communiques furthered a JCE policy. What is the evidence the SPO cites to establish any causal link between communiques and any charged crimes committed in the zones? Slide 73. The SPO must prove that communiques were a significant contribution to the commission of the charged crimes, not simply to the common purpose, as the SPO claims throughout its brief. And therefore, the temporal link between the communiques and charged crimes must be sufficiently significant. Slide 74. The SPO first relies on the evidence of Commander Remy to support the allegation that the communiques amounted to a significant contribution to the charged crimes. First, it should be noted that the SPO case is that Remy was communicating directly with the General Staff. You see there at paragraphs 354, 356, and 362 where the SPO makes these allegations. Indeed, the SPO expressly states at paragraph 362 that, quote, Mustafa and the Lap Zone Command maintained close contact with and reported to the General Staff, both in person and via satellite phone. Slide 75. This raises the obvious question. Then why didn't the JCE members communicate the criminal plan to Remy in person or through satellite phone or otherwise through its, quote, close contacts? Why would Remy need to read about policy in communiques? Why wouldn't he be receiving direct orders from the General Staff or be asking the General Staff if he should set up detention centers? The reason that the SPO has to say that the General Staff communicated the common criminal purpose through communiques to the zones, including the Lap Zone, despite, quote, close contact in person and via satellite phones, close quote, is because the SPO has no evidence of any direct orders or communications from the General Staff conveying the alleged common criminal purpose. One reasonable inference on the evidence on the SPO's own case is that if the General Staff members had a criminal plan that they wanted Remy to implement, they would have communicated that plan to him directly, and there is no credible evidence that they did. Slide 76. The SPO notes that Remy claimed that, quote, communiques were part of my military rationale. Slide 77. But Remy was speaking about Communique 54. Remy confirmed this at trial at pages 5848 to 5849 and at 5861. Communique 54 was issued in late September 1998. The prosecution's case, as charged in the indictment, is that detentions in Remy's zone began on or around the 2nd of August, and lasted until mid-September. The communique Remy mentioned seeing after the September offensive was published after his zone had been detaining people for 7 weeks. The communique could not have amounted to a significant contribution to the detentions because they post-date them. In fact, the last of the detainees in Remy's zone were released shortly after the publication of Communique 54. That's at transcript page 5726 to 5727. Slide 78. And Remy acknowledged that he had set up detention sites well before he allegedly saw the communique. That's at transcript page 5849. Slide 79. The SPO misquotes Remy at paragraph 67 of its final brief, where it cites to Remy's testimony in support of the claim that, quote, communiques were understood by KLA commanders as communicating KLA policy and authorizing measures against opponents. Remy did not say that. As you see on your screen, Remy said that he was made aware during his own trial of a document that was circulating that said that those who were working against the KLA should be prevented from doing so, but that he did not recall seeing something specific from the General Staff in relation to the matter while he was zone commander. That's at transcript page 5558. Slide 80. Next, the SPO claims that the common criminal purpose was furthered because KLA officials failed to properly define the term collaborator for subordinate units. But the fact that KLA officials in propaganda statements and political rhetoric may have used the term collaborator in a colloquial manner rather than using a legal definition is irrelevant unless the SPO can prove that the General Staff members were intending to address subordinate units, either in the form of orders or through communiques. We know that the SPO has effectively conceded that there are no internal KLA orders from the General Staff where the issue of collaborators is addressed. And as I've just mentioned, there is no credible evidence that the General Staff intended to communicate to the zones through communiques. Accordingly, the colloquial use of the term collaborator in propaganda statements is not evidence of a significant contribution to the commission of crimes. I'll turn next to the issue of regulatory and training documents. Slide 81. The SPO further claims in paragraph 71 that regulatory documents, such as the Provisional Rules of Organizing Internal Army Life, were adopted by the General Staff in July 1998 and embedded the requirement that the KLA military police be, quote, merciless toward the enemy and all those who obstruct the liberation war. The SPO's only cite in support of the allegation that these rules, which were admitted as P8, were approved at a General Staff meeting on 4 July 98, is Jakub Krasnici's book. However, there are no minutes of a General Staff meeting approving such rules on 4 July 98 in the record, and the SPO does not establish that P8 is indeed the regulation that was allegedly approved at this meeting of 4 July 1998. Furthermore, there is no evidence that Mr. Thaçit ever attended any such meeting or that he was even in Kosovo in early July. On the other hand, Zarapi, a witness whom the SPO deemed credible, when shown the provisional rules known as Exhibit P8, stated that the rules were drafted at the end of 1998 as part of the restructuring and were translated from documents from Western armies. Zarapi explained that these rules were mainly aspirational and were not implemented on the ground. Slide 82. Indeed, P8 contains regulations which contain an oath that swears allegiance to Kliko. There is reasonable doubt as to whether the General Staff would have approved regulations for distribution across Kosovo that contain an oath to Kliko alone. Slide 83. The SPO also claims that shortly after a general staff visit to the LAP zone, the KLA Public Information Service, led at the general staff level by Thaçit, issued a booklet on special warfare. And that's at SPO's final brief at paragraph 72. First, there was no KLA Public Information Service, and the SPO cites to no evidence of what this alleged entity was or how Thaçit led it. Second, the SPO misrepresents the evidence. The booklet bears the title of the LAP Zone Information Service on the last page. It was never issued by a public information service at the general staff level. In addition, as explained in our final brief at paragraphs 157 and 300 to 304, the evidence does not support the SPO's claim that special warfare was discussed during the general staff visit to LAP in October 1998. The SPO does not show, much less prove, that the October 1998 general staff visit to LAP led to the issuance of this booklet. Contrary to the SPO's claims in footnote 276, when shown the booklet, Rustam Mustafa did not recall it, so he couldn't have confirmed the authenticity of it. That's at transcript page 5651 to 5652. Turning to the third means of transmission of the common criminal purpose, meetings and reports. On Monday, Mr. Tiger said, quote, Sokol Bashota noted in his ICTY interview that collective decision-making applied to decisions about collaborators. That's at transcript 28371. Slide 84. However, there was no reference to Bashota's testimony before this court. Bashota discussed a series of meetings of the General Staff during his testimony and noted that while meetings of the General Staff were held and were taken based on a majority of the people present at any meeting, and they had a horizontal structure in the sense that they were not giving orders to each other, he also noted that not all members of the General Staff participated in every decision. Decisions could be taken in the absence of people, and each member had their own duties and responsibilities. Importantly, Bashota agreed with the explicit propositions that the following were not collegial decisions: issuance of communiques, treatment of collaborators, issuance of regulations, creation of detention centers, media interviews given by KLA members, the Holbrooke-Milosevic Agreement, the FARC Agreement, who should attend the Rambouillet Conference, the appointment of Adam Demachi, and the role of Sokol de Bruna. Upon being shown various orders signed by Zarapi, Bashota confirmed that all such decisions had been issued on his own without consulting the General Staff, i.e., not collective decisions. Bashota ultimately agreed with the proposition that there were major decisions being taken on behalf of the KLA that did not involve a collective or collegial decision-making process. Slide 85. The SPO next says that the common criminal purpose was conveyed on General Staff visits to Shala and Lap in August 1998 and to Dukajin in September 1998. We have addressed these claims in paragraphs 146 to 155 of our final brief, and I've already mentioned that Bislam Zarapi was present and participated in every one of these visits, and on the SPO's case was not a participant in discussions about the common criminal purpose. There is therefore a reasonable inference that these meetings did not transmit any criminal purpose to the zones. I want to raise an issue here about military objectives. The SPO claims that the fact that multiple KLA zones set up detention facilities means that the only reasonable inference you can draw is that they were set up by the General Staff. But this is not true. This argument fails to take into account two fundamental points. Slide 86. First, the ICRC has explained that detention by states and non-state armed groups, such as the KLA, is a reality in every conflict. It is an expected part of warfare. It is the norm, not the exception. The ICRC states that IHL is built on the assumption that all sides will detain. It would have been unusual if the zone commanders did not set up their own detention facilities. They did not need to get the idea to do so from the General Staff. Slide 87. And these are the ICRC guidelines, where it says that it may take time for non-state actors to set up systems of due process. The reason that all sides in armed conflict detain is because it is a military byproduct of war. You will capture the other side's combatants, you will need to discipline your own forces and detain them, and you will need to detain those directly participating in hostilities. The SPO here has stated that it does not dispute that the KLA had a right to lawfully detain. Slide 88. The SPO therefore has to demonstrate that even if it could prove that there were communications between the General Staff and the zones about special warfare and collaborators, those discussions were not in pursuit of legitimate military objectives, but rather were in pursuit of a political objective of the JCE members seizing power in Kosovo. Remember, if you were to conclude that abuses occurred as a result of a KLA policy to advance its military objectives, or as a result of personal grievances on the part of the KLA individual members, then you must reject the JCE mode of liability because that is not what has been charged. Their case is that all of the alleged victims were detained and abused because they were an impediment to the JCE members' political objective of gaining and exercising control over all of Kosovo. That is not the only reasonable inference you can draw on the evidence, and you therefore must reject the JCE charges in this case. This leads to our next point. The SPO has failed to prove that there was an intent to seize control of Kosovo. Slide 89. There is no evidence that the LPK had a goal to seize control of Kosovo for itself. The LPK statute here, which you see on your screen, made clear that its objective was, first, the liberation and creation of an independent state of Kosovo, and second, to create a new, free, and democratic society in line with the will of the people. There is no suggestion in the LPK statute that the LPK's objective was to seize power for itself or its members. Slide 90. In support of its claim that the JCE members had a goal to seize power for themselves, the SPO cites the political declaration number 8 at paragraph 10 of its brief, where the SPO takes a sentence out of context that says, Kosovo will be ours or it will be turned to ashes. But the rest of the text goes on to make clear that Kosovo will be ours refers to the people of Kosovo generally and not to the alleged JCE members. The statement says, Kosovo will be ours or it will be turned to ashes. We are convinced that death is nobler than life under slavery. Life under slavery here clearly refers to the people of Kosovo and not to the alleged JCE members. And then political declaration number 8 concludes by saying, our war is for freedom and for better future and real democracy. Real democracy would be incompatible with a unilateral seizure of power by the alleged JCE members. And again, it is unclear how the SPO reconciles its claim that the international witnesses and Bislam Zarapi were all uninformed about the criminal plan of the JCE members, but then relies on a public political declaration as evidence of criminal intent. The fact that the international witnesses and Zarapi did not read this declaration in the same way that the SPO spins it is itself reasonable doubt about the SPO's interpretation. Slide 91. In paragraph 27, the SPO claims that the deployment of, quote, relatively senior LPK volunteers in March 1998, quote, increased the authority of Thaçit and other LPK-affiliated KLA general staff members. The SPO does not cite any evidence to establish that these were, quote, relatively senior, close quote, people in the LPK, or how the SPO arrived at a definition of that term. In addition, we are once again faced with another contradiction in the SPO's case. How does the SPO reconcile its claim that Thaçit derived his authority from other LPK-affiliated general staff members on the one hand, with its position on the other that it was Thaçit who brought in and deployed Zarapi and other military officers to professionalize the KLA? Zarapi came into Kosovo with Thaçit, and there is zero evidence that he had anything but a good relationship with Thaçit. He never suggested otherwise in his testimony. Slide 92. In paragraphs 188 and 190 of the SPO brief, the SPO itself says that the, quote, accused's role and authority over operational matters is illustrated by their installation, appointment, and oversight of Zarapi, an experienced military officer who had operational roles in the General Staff and Ministry of Defense during the indictment period. That's paragraph 188. They go on to say in paragraph 190 that, quote, Thaçit also gave Zarapi the order to prepare professional officers and post them to the war zones. Slide 93. How does the SPO explain its position that it was Mr. Thaçit and the other accused who installed an experienced military officer, someone who was former JNA and was not part of the LPK, to run the operations of the KLA and ultimately to become the chief of staff, chief of the general staff, while also arguing that the accused excluded him from the alleged common criminal purpose in pursuit of LPK goals? You would be more than reasonable to conclude that a reasonable inference is that the accused supported Bislam Zarapi's ascent to a leadership position in the general staff because there was no common criminal purpose, and to conclude that there is a reasonable inference that Hashim Thaçit would not have encouraged the deployment of professional officers not affiliated with the LPK if he were in fact attempting to make a significant contribution to the alleged common criminal purpose. Also, Zarapi made clear in his testimony at pages 17784 to 17786 that every Albanian former military officer who made himself available to the KLA was accepted into the KLA. There is no evidence that any former military officers were excluded. Accordingly, this claim that the accused were placing ideologically LPK-aligned people in places of authority as a litmus test is contradicted by Zarapi's evidence. Moreover, the SPO in paragraph 405 says that, quote, throughout early 1999, the General Staff exhibited increasing distrust of former professional soldiers and those viewed as LDK or FARC affiliated. But the General Staff was led by Zarapi, himself a professional soldier. How does the SPO place collective blame on the, quote, General Staff, close quote, exhibiting distrust when Zarapi was in charge of the General Staff? Also, the SPO says it was Thaçit who, quote, gave Zarapi the order to prepare professional officers and post them to the war zones. On what evidentiary basis does the SPO suggest that Thaçit became distrustful of professional officers that he himself allegedly deployed and posted, especially at a time in early 1999 when Thaçit himself was not even in the country? Slide 95. I think I can do this. The SPO claims, the SPO next relies on certain public statements as evidence of an intent to seize power in Kosovo. The SPO claims in paragraph 13 of the SPO brief that by the start of the indictment period, the KLA leadership was making clear demands to be recognized as the, quote, only legitimate authority representing the Albanian people. Slide 96. It relies on Communique 44, which purports to have been sent from Pristina on 2 March 1998 by the, quote, central staff. But the SPO has not established who in the KLA leadership allegedly prepared this statement. There is no evidence of any connection to Hashim Thaçi. Mr. Thaçi was not in Kosovo at the time this was purportedly sent. Slide 97. At paragraph 16, the SPO says all political parties were to cease their independent activity and pledge absolute allegiance to the KLA. The SPO cites the political declaration number 3 of 10 June 1998, which if you read it, you will see that the SPO has grossly misrepresented the document. Nothing in here supports the SPO assertion. Again, the SPO did not put these public statements to any witness to see if anyone interpreted this as claiming that the KLA was demanding a pledge of absolute allegiance to the KLA. Mr. President, this is convenient for a break.
We'll take our half-hour morning break now. Please be back in your seats at 11 o'clock. We're adjourned until 11.
All rise.